Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. We have been discussing previous year questions in our series and I hope this is useful to you. You are referring to these to see the questions and the sections from which questions have come over the past years. In this video, we are going to discuss questions from Companies Act. There are more than 50 questions from Companies Act, therefore we'll be discussing this act in two parts. Starting with the first question, what is a public financial institution? The correct answer here is E, all of the above. Life Insurance Corporation of India, Infrastructure Finance Company Limited, or as provided under Section 2, subsection 72 of Companies Act. This is given under Section 2, subsection 72. Question number 2. Which of the following is not true about nominal capital? The correct answer here is D. Nominal capital is the contingency capital. The other statements are true. Nominal capital has all the above mentioned features which are given in the options. Section 2 subsection 8 defines it. It is registered amount that can be raised by issuing shares, which the memorandum of company authorizes as share capital, except that it is not contingency capital. It is the basic capital of the company, to which company also pays stamp duty. Question number 3. Which is appellate tribunal under Companies Act? The correct answer here is B, National Company Law Appellate Tribunal, as per Section 2 subsection 4 of Companies Act. Question number 4. What are the maximum number of persons in a private company except a one-person company? The correct answer here is C, 200. As per Section 2 subsection 68 of the Companies Act, maximum number of persons in a private company shall be 200. Question 5. To start a public company, minimum and maximum how many directors can be appointed? In a public company, minimum 3 and maximum 15 directors can be appointed. Option 3. As per Section 149 of the Companies Act, every company shall have minimum of 3 directors in case of public company and 2 directors in case of private company, 1 director in case of one-person company. A company can appoint maximum 15 directors. A company may appoint more than 15 directors after passing a special resolution in general meeting, and approval of central government is not required. Question 6. When 2 or more companies carrying on similar business decide to combine, a new company is formed. It is known as, the correct answer is D, amalgamation. Amalgamation can be done by companies for various reasons like compromise, arrangement, etc. An application for merger and amalgamation can be filed with the tribunal. Both the transferor and the transferee company shall make an application in the form of petition to the tribunal under Section 230 to 232 of the Companies Act for the purpose of sanctioning the scheme of amalgamation. Question number 7. It is a charter of a company. It is a document which, amongst other things, defines the area within which the company can operate. The first step in the formation of a company is to prepare this document. What is this document? The correct answer here is B. This is Memorandum of Association. Section 4 of the Companies Act prescribes the particulars to be mentioned in Memorandum of Association and other requirements. It is the constitution document of the company. The company cannot depart from the provisions of memorandum. If it enters into a contract or engages in any trade or business which is beyond the powers conferred on it by the memorandum, such a contract or act will be ultra vires the company and hence void. Question 8. Upper age limit of chairman is? The correct answer here is B, 70 years. As per section number 196, section 3 clause A of the Companies Act, upper age limit of chairman is 70 years of age. No company shall appoint or continue the appointment of any person as managing director, full-time director or manager who is below the age of 21 years or has attained the age of 70 years. Question number 9. When company purchases the business of another company, dash comes into existence. The correct answer here is absorption. Absorption is again another kind of merger. It is a form of merger where there is a combination of 2 or more companies into an existing company. In the case of absorption, only one company will survive and all other companies will lose their identities. Question 10. The board of directors of a company shall exercise the following functions only with the consent of company by a special resolution, which is not correct. The correct answer here is D. The consent of the company by special resolution is not required to remit or give time for the repayment of any asset due from the director. This is as per section number 180 of the Companies Act, subsection 1 clause D. Question number 11. Such capital as is authorized by the memorandum of a company to be maximum amount of share capital of the company is called. The correct answer here is B, nominal capital. Section 2 subsection 8 of the Companies Act defines authorized capital or nominal capital. Question number 12. What is the assessment year for newly incorporated company? The correct answer here is D. If the company is incorporated on or after the first day of January of a year, assessment year shall be started from 1st April of the following year. This is given under section number 2, subsection 41 of the Companies Act. If company is incorporated on or after 1st day of January, assessment year shall be started from 1st April of. Question number 13. Startup companies with the potential to grow need a certain amount of investment. Wealthy investors like to invest their capital in such businesses with a long-term growth perspective. This capital is known as. The correct answer is D. Venture capital. Startup companies which have a potential to grow need investment, and wealthy investors do invest in these. This capital is called venture capital, and investors are called venture capitalists. Such investments are risky as they are illiquid, but are capable of giving impressive returns if invested in the right venture. The returns to the venture capitalist depends upon the growth of the company. Venture capitalists have the power to influence major decisions of the companies they are investing in, as it is their money at stake. Question number 14. With respect to the appointment of proxy to attend and vote at a meeting on behalf of any member of the company, consider the following statements. The correct answer here is D. The instrument appointing a proxy can be oral or written. This is as per section number 105 of the Companies Act. Question 15. Except with the consent of board of directors given by a resolution at a meeting of the board and subject to such conditions as may be prescribed, no company shall enter into any contract or arrangement with a related party with respect to. The correct answer here is E. All of the above. Related party transactions, arrangements cannot be done in any of these aspects. This is section 188 of Companies Act. Question 16. If the quorum is not present within half an hour from the time appointed for holding a meeting of a company, the meeting shall stand adjourned to. The correct answer here is C. To the same day in next week. This is as per section 103 of Companies Act. Question 17. Which of the following is not a method by which one person company with one director can raise money? The correct answer here is issue of shares. A one-person company is a private company. A private company cannot issue shares to the public. One-person company can raise funds through venture capital, financial institutions, angel investors, etc., but not through issuing shares. Question number 18. What is the minimum age of a director? We have already covered one question with maximum age. The minimum is 21 years as per section number 196 of the Companies Act. Question number 19. A copy of Memorandum of Association and Article of Association can be given to the members on request within, the correct answer here is B, 7 days of request, as per section 17 of the Companies Act. Question number 20. What is the notice period for the annual general meeting of a company? The correct answer here is A, 21 days. Section 101 talks about notice of meeting. Question 21. First meeting of a company is held within dash days of its incorporation. The correct answer here is B, within 30 days. Section 173 talks about this first meeting of a company. Question number 22. DIN is allotted to a director of a company by whom? The correct answer here is C, by central government. Section number 154 talks about allotment of director identification number. Question 23. In case a company makes a default in transferring shares to the IEPF fund, such company shall be liable for a penalty of. The correct answer here is C, 1 lakh rupees, and if there is continuing failure, further penalty of rupees 500 for each day, subject to a maximum of 10 lakh rupees as per section number 124 of the Companies Act. Question 24. A company may issue fully paid up bonus shares to its members in any manner whatsoever out of, the correct answer is E, option A, B, C, out of its free reserves, securities premium account, capital redemption reserve account, as per section number 63 of Companies Act. Question 25. Which of the following statements is true about a red herring prospectus? The correct answer here is E. All of the given statements are true. It is issued by a company proposing to make offer of securities, issued to attract different investors, issued prior to the issue of prospectus. This is section number 32 of the Companies Act. So we'll stop here. 26 onwards we'll be discussing in the next video. If you're preparing for SEBI Legal, you have any form of doubts, you need any preparation material or guidance, you can check out our SEBI Legal online course. We at iExamBee help you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.